Hello, and welcome back to Coin Lady channel. We got some not-so-hot news in the library case yesterday. Once again, the game is done. So, officially, the library last in November, but in January, Attorney Deaton attended the hearings regarding the remedies. So the judge didn't quite accomplish what he pledged to do, but yesterday we got the ruling. There's an entire video I produced about it here. So, I won't go over that ground again and again. Let's just say I'm a little bit disappointed. It's not just me, either. He has basically broken his word from January by explicitly stating in this judgment, with all the sanctions, that he is not taking a position on secondary market transactions. So, it was a letdown. However, Attorney Deaton ultimately draws attention to a squandered opportunity in the library. In addition, this news article from a leading crypto specialist claims that Judge Torres will rule that XRP traded on exchanges is not a security. We'll have to wait and see what develops between this specific person and myself. In the case of Ripples, though, I anticipate a totally different result. I don't think we'll see the same bad thing happen again, for many reasons. Instead, I anticipate adequate and constructive transparency for XRP on secondary markets and exchanges. I should probably state up front that I have zero experience in either law or finance. I am not qualified to give you financial or legal counsel. Nothing I say should be used as a basis for making any financial decisions. I'm merely a hobbyist who likes to share his knowledge on crypto-related issues through YouTube videos, but in a casual, recreational context. Okay, Bill Hughes is a lawyer, and he practices consensus law. And he passed over the following excerpt from the decision that was made the day before. So, the library case judge has said. In its additional brief in support of the motion to limit remedies, the library also offered a brief argument, presented for the first time, that the big questions theory limits the SEC's efforts to regulate digital assets. Finally, on a more upbeat note, last year saw the implementation of a significant new EPA regulation. This jurisdiction land grab by the SEC is a clear violation of the major questions doctrine, which states that a government agency must state where it has congressional authority before taking action that will have far-reaching effects on the economy and other areas of policymaking. The SEC cannot make this claim because it lacks the authority to do the things it is proposing to regulate. The judge in this case is a librarian named Barbara Doro, and he points out that the key questions doctrine was ultimately raised, but he doesn't address it. He had already dismissed the idea. So, have a look at this. This last-minute legal argument has been waived, the judge added, assembling precedent for the idea that a party's failure to mention an issue in its opening brief constitutes a waiver of that issue. In fact, the cited Supreme Court case was decided before I held oral arguments on the cross-applications for summary judgment, thus it would have been appropriate to present an argument challenging the SEC's ability to bring this enforcement action far earlier in the proceedings. According to attorney Bill Hughes, this is a major squandered opportunity. Perhaps the library missed a really crucial argument, attorney Hughes wrote. Please be gentle with your criticism of my decision to pass up this chance. It wasn't cool then, but it is today. Given the other merit findings, it's possible that the court may have ruled the other way if they hadn't had enough time and space to give the matter the correct consideration. And fair enough, but as regards the major question doctrine, the major questions doctrine, that sounds like something that has genuine fangs, and I've read enough viewpoint from enough attorneys to be convinced that is truly the case. So, certainly, it seems like a lost opportunity in the library's situation. Well, don't be too hard on your therapy, attorney Hughes here seems to be saying in a polite way. That's terrible. This is what John had to say after lawyer Deaton retweeted it. Not even I am interested in playing Monday morning quarterback. Since, as Bill points out, the major questions doctrine was less in vogue back then, let's talk about it. I'll halt here to say that I think it was wrong to dispute only the third prong of the Howey test and not the first two. No, I've always found that to be rather perplexing. Why not just go in with both feet, arguing on every legal front you can. Why give in until you've exhausted every possible argument against the claim that your investment meets the first and second requirements of the Howey test? If you're being honest, you won't give in until you've exhausted every possible argument against the claim that your investment meets the Howey test. That appears to be a really bad idea right now. That, in my opinion, is a much bigger blunder. But, as John continues to explain, library patrons may use their LBC tokens to gain access to the platform, allowing them to create and share more engaging content and ultimately expand their channels. Most people who own LBC tokens didn't buy them with the intention of making a profit. It's also worth noting that the SEC isn't always reliable when it comes to supplying horizontal or common vertical commonalities. Even though the SEC frequently conflates alignment of interests with shared enterprise, the two concepts are distinct. The SEC has disavowed the common enterprise element from the Howey test because of its unease with it. The SEC states that it does not regard common enterprise to be a part of an investment contract in footnote 10 of the SEC's 2019 framework. This is fantastic, and you're going to like it. I may have mentioned it twice in the history of my channel. And if you haven't already heard this, prepare to have your mind blown. What the SEC is doing here, and they just come right out and say it, blew my simple little moving family vehicle mind. Yes, indeed. There was no precedent for the Howey test in 1946 Supreme Court decisions. Nope, we're not going to pull the trigger on a purchase. We're not going to do it because we're cowards. It is ours, us. And we actually carry it out. In a word, we need assets. Please refer to footnote 10. This is exactly what Lawyer Deaton is referring to. They state explicitly that this is not going to be used as a precedent. Since we are the SEC, we cannot rely on prior decisions under this rule as binding precedent. Anyway, here's what's in footnote 10. Federal courts require either horizontal commonality or vertical commonality to satisfy the common enterprise prong of the Howey test. They are so confident that they are arguing that this is necessary in court. They get it, but they didn't go into detail about the two types of vertical commonality that center on the relationship between the promoter and the body of investors, horizontal commonality and vertical commonality, and how the fortunes of each individual and individual investor are tied to the fortunes of the other investors through the pooling of assets, usually combined with the pro rata distribution of profits. And then they write, so check this out. However, the Commission does not insist on any certain degree of vertical or horizontal similarity. Neither does it treat a shared business as a separate component of an investment agreement. That makes the odds on all four prongs of the Howey test a little bit less certain. Same old, same old. Do you really think this is happening? What a terrible idea. One crypto industry insider in this piece expresses cautious optimism about the SEC versus Ripple case, claiming that Judge Torres will rule that XRP traded on exchanges, especially extra fiat exchanges, is not a security. Here then is the tweet. Ashley Prosper, writing in my opinion, lays out the following, and then organizes it such that it can be understood as though it were being said by an SEC insider. After that, it sounds like a reaction from Judge Torres, which is not the case. If I may clarify, what would this be set at? Therefore, according to the SEC expert, purchasers of XRP were placing their faith in Ripple's attempts to drive up the value of XRP. Since you didn't interview XRP investors, Judge Torres, you can't tell me what they were thinking. You even agree that having this information could have altered your findings. Furthermore, I have around 3,000 affidavits from real XRP holders that disprove your findings. In case that isn't enough evidence, I also have around 15 Amici briefs, many of which show that some kind of XRP exists. Token holders of XRP were not just sitting on their coins, but were actively transacting in them. As for an investment agreement between Ripple and these XRP holders, the SEC has yet to present even a single one. Thus, the Howey test fails to be satisfied in at least one respect. As a result, the secondary market sale of XRP is not a distribution of a security. All done. Let's stop the note for now. That is accurate without a doubt. Even if you're going to convince me that tapping jets and spending bits is a good investment, I just don't understand how it works. These infrastructures represent a financial outlay. But no, it serves a practical purpose. Just the facts. That is blatantly evident. So, this is a major departure from the library scenario. Additionally, perform a right-hand press. Given the foregoing, I fail to see how Judge Torres could rule that XRP secondary transactions are not securities. Yeah. And by the way, I couldn't agree more. For this reason, if I had to wager, she wouldn't be my second choice. Perhaps I'm wrong, but it seems like market transactions are not constant. Fun visitors are welcome. I'm going to have to agree and say yes. I'm going to have to agree and say yes. The SEC should take credit for developing the embodiment hypothesis. How a judge on tour can avoid addressing that is beyond me. I don't see why that would be so important to our deliberations. However, time will tell. You shouldn't base any purchasing decisions on what I say because I'm not a financial counselor. Please like and subscribe my channel. See you in the next video. Bye.